Another area of protection that the Service Members Civil Relief Act can provide is protection in default judgments. A default judgment is a type of a judgment that happens when one party, normally the party to the lawsuit that's responding to an initial lawsuit action, doesn't respond within the time frames required by the court. When that happens, the court can issue what's called a default judgment. That's a judgment without any action by the responding party. There are certain circumstances where service members can have protections from those types of judgments. If they weren't notified of the action and they have an issue that would allow them to reopen that judgment. Now, if that's your situation, or you are aware of a default judgment, you need to speak to an attorney right away, because the window for reopening a default judgment is very small. The next area that we're going to talk about is retired pay and disability. These are actually two separate areas that can in and of themselves be very complicated. But again, because this is an overview, we're going to put them together and talk about them similarly so that you just have an overview and a basic understanding of how these two areas can impact a divorce situation. The first thing you have to look at in retired pay is whether the service member is eligible for retirement. 20 years is the standard for military retirement. On the active component side, an active component or active service member will receive military retired pay when they leave military service, whether that's 20 years or sometime after 20 years. They'll start receiving that retired pay right away. For the reserve side, the reserve component, that is someone in the National Guard or someone in the reserve of that military service, whether it's Army, Navy, Air Force, Marine, Coast Guard, those people will start receiving their military retirement when they reach age 60. There are some exceptions to that for combat service, but in general, it's going to be 20 years or age 60. And whenever they receive retired pay, whenever they start receiving that, that's when the former spouse is going to start receiving their portion of the retired pay if military retirement is divisible or has been divided in that divorce. When you're looking at dividing military pension in a divorce, the first thing you look at is what's called the marital share. And the marital share is discussed, again, remember that big law that we talked about in the beginning, the Uniform Former Spouses Protection Act. It gives states the authority to treat military retired pay as marital property and divide it, again, per the state law. So when we look at the marital share, there's no specific required percentage. But in general, you can't go over what's called 50% of the disposable retired pay. And there are certain definitions for what disposable retired pay is. That's something that you should talk to your attorney about to have an understanding of what the disposable pay would be. But again, the Uniform Former Spouse Protection Act would limit that divisibility to 50% of that disposable rate. Now, what might be fair in your situation, depending on length of marriage, length of service, all different factors might be different. So many spouses receive a share other than 50% of the disposable retired pay, just depending on the situation. There's also no minimum number of years for divisibility. Many people think that 10 years of marriage is required for the pension to be divisible, and that's just simply not the case. If you have a marriage that lasts for 10 minutes, it's going to be divisible. You're just not going to get a very big share, right? Because the pension divided is going to be very small. That marital share is going to be your 10 minutes. So the marital share is what you look at first, and then you'll look at the number of service years of that service member, and there are several ways that you can divide that military pension. A couple of them we'll talk about just briefly, and again, this area is so complicated that it's not something that I can explain to you thoroughly in a presentation like this. It's something that's very situational, and it requires an expert. The ways to divide military pensions in general include a fraction, a hypothetical award, or a straight dollar award. Now, just so we can understand the differences between these three types, the fraction award is awarded up to that 50% of disposable retired pay. And the way that it's stated in the decree will say a percentage of that fraction. An example of this would be the wife shall receive 37% of the husband's disposable retired pay, and then there will be fractions inserted by the court. So one of the fractions would be the total number of years of marital pension service, meaning the number of years that the marriage overlapped the military service. So if you were married for 3 years, let's say, you'd have 36 would be in that numerator. And then the denominator is going to be the total months of service for the service member. And that's something that if the service member is still in service, you might not know at the time when you're doing this. And that's something that can be inserted later by the Defense Finance Accounting Service. When you calculate the actual amount of the military retirement at the time of the retirement, that denominator number would be inserted. The hypothetical award is a similar type of award, but it's often used for service members who are still in service. And when a service member is still in service, sometimes it's hard to calculate what rank they might receive and how the entire package might look for what is available to divide with the spouse. In those situations, it's beneficial for the parties to decide on a set of factors that are agreeable to both parties for division of that military retirement. A hypothetical award can look something like wife is granted 40% of what a staff sergeant, that's an E6 for the Army, would earn if they were to retire with 20 years of military service. That set of information can allow the court or allow the Defense Finance Accounting Service to look up what that amount would be and then do the fraction of that amount of retired pay that would be awarded to the former spouse. It probably still seems really complicated. So once you start to hear all of that, you understand how complicated these types of divisions can be. Again, you should definitely talk to an attorney who is familiar with military pension division if this is your situation. The other way to do this is a straight dollar award. It's probably the most uncomplicated of all of them, but it doesn't always produce the best result for either party. So again, it's very situational as to how you divide it. A straight dollar award is simply what it sounds like. A dollar amount that would equate or mean the same thing as any of these types of percentage awards. So it's a lump sum payment. This can work if you're offsetting different types of assets within your divorce. So if you have other types of retirement assets, say a 401k from a civilian job or other types of savings, you can offset the amount of military retirement that this former spouse might be entitled to offset from another asset. And a straight dollar award is a way to do that, to evaluate both assets. And again, you're going to want somebody to do those valuations who understands how to value those assets before you agree to a specific number.